There's some other policy changes recently, some of which you may have heard of. The big news about border processing at the northern border is for Canadian L1s. So under NAFTA, NAFTA didn't create the L1 visa category, but it permitted Canadians to present those petitions directly at the border and have an adjudication there in conjunction with an application for admission. And what the regulations provide is that they can be processed directly at the port of entry. The regulations are silent as to whether that includes the initial petition for L1 status or whether it also includes extensions of L1 status. And since NAFTA was passed, for the last 2 decades, that regulatory provision has always been interpreted as requiring CBP to do L1 adjudications both for initial and extended L1 petitions at the port of entry, at any land border crossing along the U.S.-Canada border or pre-clearance office at a Canadian airport. And that's always what has been done, and that's what the regulation has always been understood to indicate. Just a few months ago, there seemed to be a change in whether CBP was willing to process L1 extensions at the port of entry. This was not a change in policy that was announced. It was a change in policy that people became aware of when their clients were turned away and told, we don't do extensions anymore. And the way that it's been communicated is that this has always been the policy. We simply never applied it before. And that's an interesting departure. I will tell you from meeting with CBP as a liaison for AILA in person, they have been very open for a long time about the fact that they want to be out of the business of doing adjudications at the border. They perceive the purpose of their agency to be that of law enforcement, and they do not like doing adjudications. So this new policy is paring back their adjudicatory function.